Hi, I'm back. We'll continue reading the Arbitration Act that we had left off yesterday. And just to give you a heads up, I love reading and I'm here to read books. If you like any books to read, I'm here to read it. Just name it or send it across to me on my email address sudhamalla@gmail.com, and I'll be there to read it for you. And please do like and subscribe to my channel. I'm new here. Please subscribe it so that I can continue reading a lot of books for you guys. I myself love reading, and reading for you would give me a great opportunity for every listener to have that hold of any books. It's just read and read for me. I will read for you. The more you the more you subscribe to my channel, it will be more easier for me. And I would like that you would tell me what you would like to listen. So I'm here to read. And as I was telling you, I come from a law background, and so here I am reading some books which are beneficial to me. So I hope it is beneficial for somebody else. So I have started reading my Arbitration Act. I have started reading the Arbitration Act. You can find the other links. And so I'll continue to read. Yesterday we were about to discuss the form, contents, and correction interpretation of arbitral award. So we'll start. Section 31 prescribes form and contents of arbitral award and makes setting out the reason for the award as a mandatory provision. It shall be rendered in writing and shall bear the signatures of the members of arbitral tribunal. Subsection 5 envisages the delivery of signed copy of the arbitral award by the arbitral tribunal to each party. The arbitral tribunal may at any time during the arbitral proceedings make an interim award on any matter with respect to which it may make a final arbitral award. Subsection 6. The definition of arbitral award in section 2, subsection 1, subsection C. I hope I'm right by saying this. 2 in brackets 1, then in brackets C. So I used to say 2 section C subsection 2 section 1 subsection C. Oh, sorry. But I don't know what is correct. In section 2 subsection 1 subsection C is inclusive of an interim award. In terms of subsection 7, subject to the parties agreeing as far as the award is concerned about payment of money, the arbitral tribunal is empowered to award interest at the rate it considers appropriate, either on the whole amount involved or for a part of the amount for the entire or part of the period between the date of arising of cause of action and the date of the award. Clause B of subsection 7 envisages the subject to the award otherwise directing the arbitral tribunal shall carry interest at the rate of 18% per annum from date of award to payment on the amount directed to be paid. The Constitutional Bench in Secretary Irrigation Department, Government of Orissa versus G.C. Roy, AIR 1992, Supreme Court Decision 732, considered an arbitrator's power to award interest pendente lite. It was held that when the arbitrator to entertain a claim for interest, the arbitrator was competent to award interest pendente lite. This power of the court under section 34 of CPC to award interest is in order to do complete justice between the parties. Correction and interpretation of an award. Section 33 of the Act deals with correction and interpretation of an award or additional award. The arbitral tribunal may correct the award within 30 days of the receipt of the award. For that purpose, a party with notice to the other party may request the tribunal to correct any computation errors, any clerical or typographical errors, or any other errors of a similar nature occurring in the award. If so agreed by the parties, a party with notice to the other party may request the tribunal to give an interpretation of a specific point or part of the award. Subsection 1 of section 33 also provides that the parties may agree upon a period of time other than 30 days for the request. If the tribunal finds that the request is reasonable, it shall make a correction or give an interpretation within 30 days of the receipt of the request. However, the tribunal may extend, if necessary, the period of time within which it shall make a correction, give an interpretation of arbitral award under the provisions of subsection 6 of section 33 of the Act. The interpretation shall be treated as part of the award. Likewise, the arbitral tribunal may also correct any errors on its own within 30 days from the date of the award. The tribunal cannot extend that time. All right. Okay. It's about the correction and interpretation of an award that the arbitrator has given. Going ahead, next comes additional award. I'll just show you the book. This is. I'm actually not sound technically. I want to show you the page, but I don't know how to put it in the video. Sorry. So next is additional award. Subsection 4 of section 33 contains provisions for making additional award. It provides that unless otherwise agreed by the parties, a party with notice to the other party may request the tribunal to make an additional award as to claims presented in the arbitral proceedings but omitted from the arbitral award. Such request may be made within 30 days from the receipt of the arbitral tribunal. If the arbitral tribunal considers the above request reasonable, the tribunal shall make the additional arbitral award within 60 days of the request. The tribunal, if necessary, may extend the time of 60 days. The provisions of section 31 of the Act shall be applicable to a correction or an interpretation of the award or to an additional award. Enforcement of award. Section 36 of the Act provides that if the time of making an application to set aside the award has expired or the application has been refused, the award shall be enforced under the Code of Civil Procedure 1908 in the same manner as if it were a decree of the court. Going ahead, it asks, there is a problem. The question is, what is the scope of court's intervention in arbitration process? Discuss the grounds on which arbitral award could be set aside. Intervention of the court is envisaged under the Act. Under the new Act, the civil courts can intervene in the arbitration proceedings as stated in Section 5 of the new Act in the following circumstances only. Where the objections are raised regarding non-existence of arbitration agreement, where objections are taken for improper appointment of the arbitrator, that is Section 12, where it is challenged that disputes referred to arbitration are not covered by the arbitration agreement. So it's asking about the scope of the court's intervention in arbitration process. Okay, what are the grounds? These are the grounds. Intervention of the courts is envisaged under this Act. Under the new Act, the civil courts can intervene. The civil courts can intervene in the arbitration proceedings as stated in Section 5 of the new Act in the following circumstances only. 1. Where the objections are raised regarding non-existence of arbitration agreement, where objections are taken for improper appointment of the arbitrator as defined in Section 12. Third, where it is challenged that the disputes referred to arbitration are not covered by the arbitration agreement. Fourth, where it is alleged that the arbitrator has misconducted himself and the arbitration proceedings. Fifth, where the presence of bias on the part of the arbitrator is alleged and such like instances as mentioned in Section 12, 13, 14, 15, 32, 33, 34 and 36 of the 1996 Act. Okay, sorry, excuse me. It may be noted that court's intervention is also possible under Section 8. that section was left out. Sorry. Under Section 8, reference to arbitration. Section 9, interim measures by the court. Section 27, court's assistance in taking evidence. Section 37, appeal to a court from an order of the arbitral tribunal. And Section 39, court's power to order costs of arbitration. Provisions regarding setting aside an award. The parties can approach the court for setting aside the award. Section 2, subsection E, specifically provides that court means the principal civil court of original jurisdiction in a district, including High Court, and excludes any civil court of grade inferior to such principal civil court or any court of small causes. An application may be made in accordance with subsection 2 and subsection 3 of the Section 34 of the Act for setting aside an arbitral award. Subsection 2 of Section 34 stipulates the following grounds on which the award may be challenged before the court. That is Section 34. 1. Incapacity of a party. 2. Invalidity of the arbitration agreement. 3. Party applying was not given proper notice of the appointment of the arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. Award. 4th. Award not in accordance with the terms of submission to arbitration in regard to the dispute. 5th, arbitral tribunal not properly constituted or the arbitral procedure was not in accordance with the agreement of the parties. 6th, subject matter of the dispute not capable of settlement by arbitration under the law for the time being in force. 7. Award being in conflict with the public policy of India. These are the provisions regarding setting aside an award. Explanation to subsection 2 B provides that an award would be in conflict with public policy if it is induced or affected by fraud or corruption, or violates Section 75 or Section 81 of the Act relating to confidentiality and admissibility of evidence in other proceedings. Section 34, Clause 3 of the Act prescribes the time limit for making an application for setting aside an arbitral award. The application cannot be made after 3 months have elapsed from the date of which the party making that application had received the arbitral award, or if a request had been made under Section 33 from the date on which that request had been disposed of by the arbitral tribunal. It is further provided that the period of 3 months could be extended to a maximum of 30 days by the court, but not thereafter, if the court is satisfied that the applicant was prevented by sufficient cause from making the application within the said period. Problem: when is an appeal maintainable against the orders? Section 37 of the Act provides that an appeal shall lie from the following and from no others: to the court authorized by law to hear appeals from original decrees of the court passing the order, namely granting or refusing to grant any measures under Section 9. B. Setting aside or refusing to set aside an arbitral award under Section 34. An appeal may also lie against the decision of the arbitral tribunal: A. Accepting the plea referred in subsection 2 or subsection 3 of Section 16, or B. of Section 17 of the Act relating to granting or refusing to grant any interim measures. Section 37, Clause 2. Section 37, Clause 3 prohibits making of second appeal from an order passed in appeal under Section 37, Clause 1 and 2 of the Act, but the right to appeal to the Supreme Court is always open to the party aggrieved. The Supreme Court may, in its discretion, grant special leave to appeal where the needs of justice demand interference by the highest court of the land. The power conferred upon the Supreme Court is a residuary and extraordinary. However, the court, in accordance with the well-established judicial principles or the well-established norms of procedure, which has been recognized as long as precedents, shall exercise it. Now, so we saw where the appeal is maintainable against the orders. Now we'll go ahead with discuss the relevant provisions of Arbitration and Conciliation Act 1996 dealing with foreign awards. The Arbitration and Conciliation Act 1996 deals with the enforcement of foreign awards and consists of two chapters in Part 3. Chapter 1 relates to the New York Convention Acts, and Chapter 2 of the Geneva Convention Awards 1958 and the Geneva Convention on the Execution of the Foreign Arbitral Awards 1927 deals with rules of procedure for enforcement of foreign awards in different countries which are parties to these conventions. Okay. As India is a party to both the convention, that is the New York Convention Awards and the Geneva Convention. As India is a party to both these conventions, the relevant provisions relating to the enforcement of these awards have been incorporated under the Act of 1996. New York Convention Awards. Foreign award is defined in Section 44 of the Act as an award on differences arising between persons out of legal relationships, whether contractual or not, which are considered to be commercial under the laws in force in India and made in pursuance of an agreement in writing for arbitration to be governed on the recognition and enforcement of Foreign Awards Act 1958 in the territory of foreign state notified by the Government of India as having made reciprocal provisions for enforcement of the convention. Section 45 of the Act relating to New York Convention starts with non-obstante clause. It provides that whenever a judicial authority is seized of an action in the matter in respect of which there is arbitration agreement covered under the New York Convention, the court shall refer the parties to the arbitration unless the court finds the agreement null and void, inoperative, or incapable of being performed. Section 45 of the present Act is analogous to Section 3 of Foreign Awards. Recognition and Enforcement Act 1961. In Renu Sagar Company and General Electric Company AIR 1985 Supreme Court 1156, the Supreme Court stated the following preconditions for the court to exercise its power to stay proceedings in respect of a matter to be referred to arbitration. There must be an agreement to which Article 2 of the Convention set forth in the first schedule applies. A party to that agreement must have commenced legal proceedings against another party thereto. The legal proceedings must be in respect of any matter agreed to be referred to arbitration in such agreement. The application for stay must have been made before filing the written statement or taking any other step in the legal proceedings. The judicial authority is satisfied that the agreement is valid, operative, and capable of being performed. The judicial authority has to be satisfied that there are disputes between the parties with regard to the matters agreed to be referred. It has been held in Messrs. Orma Implex Private Limited versus Nisai Ash Private Limited in 1998 that where a sales contains an arbitration agreement and the plaintiff filed a suit for recovery of certain amount on the basis of that contract, then the plea of the plaintiff that he was not aware of the arbitration agreement existing under the sales contract cannot be believed and the civil suit should be delayed. When foreign award binding, any foreign award which would be enforceable under this chapter shall be treated as binding for all purposes on the persons as between whom it was made and may accordingly be relied on by any of those persons by way of defense, set off, or otherwise in any legal proceedings in India. And any references in this chapter to enforcing a foreign award shall be construed as including references to relying on an award. Section 46. I'll read it again. When foreign award binding. Any foreign award which would be enforceable under this chapter shall be treated as binding for all purposes on the persons as between whom it was made and may accordingly be relied on by any of those persons by way of defense, set off, or otherwise in any legal proceedings, and may accordingly be relied. Okay, so that foreign award may accordingly be relied on by any of those persons by way of defense, set off, or otherwise in any legal proceedings in India, and any references in this chapter to enforcing a foreign award shall be construed as including references to relying on an award. Section 46. Jurisdiction of the court. Section 47 sets forth the formal requirements necessary to apply for enforcement of a foreign award. A foreign award can be enforced under this chapter if it fulfills two fundamental requirements, namely, that the parties have submitted to the arbitration by an agreement which is valid under its governing law, and the award is valid and final according to the law which governs the arbitration proceedings. The claimant therefore must plead and prove both the existence and the validity of the arbitration agreement and the award, and that, depending on the context, the proceedings may be classified as a claim on the award itself or on the submission agreement. The law governing the arbitration agreement governs the jurisdiction of the tribunal to render the award, and the validity of the award depends on the law governing the arbitration proceedings. Conditions for enforcement of foreign awards. Enforcement process is a three-dimensional process integrated in section 47, 48 and 49. It commences with section 47 and concludes with section 49. A party seeking enforcement of foreign award has to make an application under section 47 accompanied by the documentary evidence set forth in it. Then the party against whom the award is invoked may resist the enforcement on one or more of the defenses enumerated in section 48 subsection 1 A to E. He has to satisfy the court by furnishing proof to the court that the award suffers from one or more defects set out on these provisions. If the court is satisfied that the award suffers from such defect, it may refuse enforcement of award. Then there are two more defects set forth in section 48 subsection 2 vice non-arbitrarily of the subject matter of the award and conflict of the enforcement with the public policy of India. These grounds need not be pleaded or proved by the party resisting the enforcement. The court may decide them ex officio and refuse enforcement if it finds that any one of these exists. If the party resisting the enforcement fails to furnish proof of the existence of the defects or the proof furnished by it is not satisfactory, the court has to enforce the award. Likewise, if the court does not find the existence of defects mentioned in section 48 subsection 2, it will enforce the award. Once the court is satisfied that the award is enforceable by virtue of section 49, it will enforce the award as a decree of the court by coercive sanctions of seizure and attachment of the properties, bank accounts and other assets situated in its jurisdiction. Geneva Convention awards. Under the Geneva Convention, in order to obtain recognition or enforcement of a foreign arbitral award, it is necessary to show that the arbitration agreement is valid, subject matter of dispute is capable of settlement by arbitration. The award is made by a validly constituted arbitral tribunal. The award has become final in the country in which it has been made. Recognition and enforcement of award is not contrary to the public policy of the country wherein it has to be enforced. Even if these conditions are fulfilled, the recognition and enforcement of the award can be refused if the court is satisfied that the award is annulled, sufficient notice of the arbitration proceedings is not given to the party. Third, the award does not deal with contemplated differences. It was, however, felt that the Geneva Convention suffered from certain defects which hampered the speedy settlement of disputes through arbitration, and thus the New York Convention was entered into. The New York Convention seeks remedy those defects by providing for much more simple and effective method of obtaining recognition and enforcement of the foreign awards. The party against whom the award is sought to be enforced can object to recognition and enforcement of the foreign award on the following grounds: of incapacity of the parties or invalidity of the agreement, lack of proper notice of appointment of arbitrator or arbitral proceedings, that the award deals with differences not contemplated within the submission to arbitration, that the composition of the arbitral authority or procedure does not accord with the agreement, that the award has not as yet become binding, if that the subject matter is not capable of settlement by arbitration, that recognition and enforcement of the award is contrary to public policy. None of these grounds postulates a challenge to the award on merits. Both the convention have been incorporated as schedules to the 1996 Act and thus have been made a part thereof. The UNICITRAL, the United Nations, we read it yesterday, right? UNCITRAL. It is United Nations. Yes, it's United Nations Commissions on International Trade Law. UNCITRAL. The UNCITRAL model law states an arbitral award, irrespective of the country in which it was made, shall be recognized as binding and, upon application in writing to the competent court, shall be enforced. The choice of place of arbitration for international arbitration is guided by the convenience of the parties with little or no connection with the state where the dispute takes place. Going ahead, filing of foreign awards in Indian courts. This is very important. This is really important. The Indian courts would not be satisfied about the enforceability of the foreign award if it is proved by the party against whom it is sought to be enforced that the parties to the agreement under the law applicable to them were under some incapacity, or the agreement was not valid under the law to which the parties have subjected, or in the absence of any indication thereof under the law of the place of arbitration, or there was no due compliance with rules of fair hearing, or the composition of the arbitral authority or its procedure was not in accordance with the agreement of the parties, or filing of such agreement was not in accordance with the law of the place of arbitration, or the award has not yet become binding on the parties, or had been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. The award will not be enforced in India if the court is satisfied that the subject matter of the award is contrary to the public policy. However, an appeal lies against the order of the court refusing to enforce the award to the next higher court. The new law affords only a restrictive right to the courts in India to refuse enforcement of a foreign award, and this is in accordance with the wishes of the international commercial community to the effect that judicial control on the award should be restricted to the barest minimum. Okay, the new law affords only a restrictive right to the courts in India to refuse enforcement of a foreign award, and this is in accordance with the wishes of the international commercial community to the effect that judicial control on the award should be restricted to the barest minimum. The approach of the Supreme Court of India in the matter of arbitration award is that arbitration award should be sustained and not destroyed by a court. The second aspect of public policy will be whether the enforcement of the award would be against the most basic notions of morality and justice in India. This, however, will depend upon the facts of a case, and the approach of the court should always be to enforce an arbitration award ensuing from an international arbitration and advert to the plea of public policy only in rare cases in a most rational and enlightened manner. Conciliation. Okay, we'll read about conciliation. Conciliation is an informal process in which the conciliator, the third party, tries to bring the disputants to an agreement. The parties present their case to a neutral judge, that is the conciliator, who assists in settlement, which is normally acceptable to the disputing parties as it is coming from a neutral source. The conciliator is not an arbitrator. The conciliator is not an arbitrator and is not bound by law in order to do. The conciliator is not an arbitrator and is not bound by law in order to do what he thinks just and reasonable. This is an accepted method of resolving differences and disputes across the developed world. Excuse me. Distinction between conciliation and arbitration. An arbitration clause in the contract may provide Okay, distinction between conciliation and arbitration. 1. An arbitration clause in the contract may provide that before restoring to arbitration, the parties should first attempt to settle the dispute amicably amongst them and initiate arbitration proceedings only if such attempt fails. But no such stipulation could be made under conciliation agreement. Arbitration agreement is enforceable by courts while conciliation agreement is not so. Arbitration guarantees a binding award. Conciliation, the most, is facilitative and evaluative. Conciliator cannot impose a decision on the parties, whereas arbitration presents an alternative to the judicial process. Arbitrator is bound to conduct the arbitral proceedings in accordance with the rules of natural justice. The conciliator is not trammeled by such constraints. A party may put an end to the attempt to settle the dispute at any moment during conciliation proceedings, but it cannot unilaterally be ended in arbitral proceedings. Procedure for conciliation. The conciliator, when appointed, may request each party to submit a statement setting out the general nature of the dispute and points at issue. Copy is to be given to the other party. If necessary, the parties may be asked to submit further written statement and other evidence. The conciliator shall assist the parties in an independent and impartial manner in their attempt to reach an amicable settlement. That is section 67, subsection 1. The conciliator is to be guided by the principle of objectivity, fairness, and justice. He is to give consideration to the following matters: rights and obligation of the parties. Second, trade usages. And third, circumstances surrounding the dispute, including previous business practices between the parties. Section 67, subsection 2. He may at any stage propose a settlement even orally and without stating the reasons for the proposal. Section 67, subsection 4. He may invite the parties for discussion or communicate with them jointly or separately. Section 68. Parties themselves must in good faith cooperate with the conciliator and supply the needed written material, provide evidence, and attend meetings. Section 71. If the conciliator finds that there exist elements of a settlement which may be acceptable to the parties, then he shall formulate the terms of a possible settlement and submit the same to the parties for their observation. On receipt of the observation of the parties, the conciliator may reformulate the terms of a possible settlement in the light of such observation. If ultimately a settlement is reached, then the parties may draw and sign a written settlement agreement. At their request, the conciliator can help them in drawing up the same. That is section 73, subsection 1 and 2. Legal effect. What is the legal effect? The settlement agreement signed by the parties shall be binding and binding on the parties. Section 73, subsection 1. The agreement is to be automated by the conciliator. Section 73, subsection 4. The settlement agreement has the same status and effect as if it were an arbitral award rendered by the arbitral tribunal on agreed terms. Section 74 read with section 30. The net result is that the settlement can be enforced as a decree of court by virtue of section 36. So it can be enforced. Okay. Under section 72, a party may submit to the conciliator his own suggestions for the settlement of a dispute. Such suggestions may be submitted by him on his own initiative or on the conciliator's request. The net result of section 66, section 67, subsection 2 and section 67, subsection 3 can be stated as follows. 1. The conciliator is not bound by the Code of Civil Procedure 1908 or the Indian Evidence Act 1872. Second, the conciliator is to be guided by the principles of objective fairness and justice. 3. Subject to the above, he may conduct the proceedings in such manner as he considers appropriate, taking into account a. the circumstances of the case, b. wishes expressed by the parties, c. need for speedy settlement. The new law has definitely instilled a lot of confidence in the foreign investors as they are familiar with the UNCITRAL the model that is the basis of for the new act, and the Indian law now provides for an equally quick, speedy and cost effective remedy as any other law in the world. So next we will read law of equity. Okay, I'll start in the next segment. I hope you like my reading. I know I'm not that great, but I'm trying to. And if you have any suggestions, please feel free to comment below. And please subscribe to my channel. And if you want me to read any other book, please let me know. I am willing to read any book that you would like. And so I'll see you next time. See you.